All right, I'm going to give everybody just a moment to get all logged in, but I want to say welcome to everybody. We are very excited to have you here with us today. As you know, my name is Ginger, and I'm the Executive Director of Connectionology, and I am thrilled that we were back today for a very special Paralegal LAWboratory. We've not done one of these in a while, and what is amazing is that we have Miss Joy with us today, who has a ton of experience. You're going to hear all about her background. And we have Marjorie back with us today, and I have missed her so much, so it's great that she's with us. I highly encourage you guys to ask your questions. Please put those in the chat box or in the Q&A box. We'll keep an eye on them and ask them throughout the webinar. And we want this to be interactive, so feel free to, again, ask questions. But we're going to have a great time, and then later you're going to meet my amazing partners over at HMR, On Point Legal Nurse Consulting, Fox AE, and Emotion Track. So we're going to have a lot of fun. We're going to learn a lot, and I hope that you enjoyed today's webinar. I'm going to go ahead and get started because we have a lot we're going to be covering. For those of you who do not know, my dear friend and wonderful trial lawyer, her name is Marjorie Levine, and she has considerable experience in managing and navigating all phases of complex legal disputes. She works with the John Romano Law Firm down in West Palm Beach. And prior to joining the firm, she focused her practice on disputes that involved a wide range of medical malpractice, nursing home negligence, construction projects, consumer financial services litigation, as well as appellate work and environmental enforcement and litigation. And she graduated from the the George Washington University with a degree in biology as well as environmental studies. And then she attended the Pace University School of Law, where she graduated with environmental law certificate. And she's licensed to practice in Florida, New York, and New Jersey. And then outside of her practice, she serves as the chairperson of Angler Action Foundation, which seeks to improve and protect marine habitat through responsible fishery and marine regulation, as well as conservation, preservation, and restoration. And one thing I'm also very proud about Marjorie is she has done a huge amount of work with the Camp Lejeune cases. So if you are working on any of those, if you have questions, please reach out to her because she is a wealth of information and we want you to definitely connect. So Marjorie, I'm going to hand the webinar over to you, and I hope everybody enjoys it today. Thanks for being with us.
So much, Ginger. That was so nice of you. I love working with Ginger and Joy, who I have the absolute pleasure of introducing. Joy Auerbach is a personal injury senior case manager and freelance legal consultant supervising case managers and associates in all aspects of intake to trial. Prior to earning her JD at UWLA, which is the University of West Los Angeles, Joy held legal support staff positions from receptionist to legal assistant. So she's been everywhere. She's been a paralegal, she's clerked. She has experience doing everything that an attorney could possibly need. She's drafted pre-lit and litigation demands, discovery responses, attended DMEs, attended depositions, of course, prepared her attorneys for depositions. She's attended mediations and prepared for that, and arbitrations and trials. So she is a wealth of information. She specializes in the supervision of medical treatment for injured victims and enjoys reviewing medical records. We have that in common, Joy. And finding the gold in the max for all of her cases. So I'm very happy to be here with you and to help you in any way possible through this presentation. Do you have anything to say before we get started? I'll pull up the slideshow.
Well, likewise, it's very nice to meet you, Marjorie, and please feel free to interject because you are actually a person who takes depositions and defends depositions. For me, I do all of this support work and I always have, and I've attended a lot of depositions, but if you could go ahead because you're actually the person who works doing them, please interject and feel free to interject and ask any questions or bring out any points that would be helpful.
All right, so let's get on started. I'm going to pull up the presentation now. Sorry about that. All right, Joy, can you see our presentation?
Yes, I do.
All right, wonderful. Let's get started.
There we are, but we're not the people behind the desk, but there we are. And so what I wanted to say was that, and I won't make this joke again, but I always start by saying, back when the dinosaurs roamed the earth and I worked in the legal field when I first started, I worked from intake to trial. I worked the entire case, usually with a sole attorney, sole proprietor, and we would work from, as I said, from intake to trial. And so as the case progressed, I always knew what was going on in the case, and I was able to then tell the attorney things. And so by the time we came to the deposition, we were all pretty much prepared and ready to go. That changed when departments of pre-lit and litigation started coming about. And when different departments came, there was just a little bit of a difference now in handling cases. And so by this time, my first job, the first job I ever did was I worked in a law firm as a receptionist, and I organized documents for a class action called the Bullion Reserve case. And when I did that, I read every litigation document. I actually had to index them. I guess that was pretty mean because the lawyers had to pay me to index them, but I was reading them so that I could have an understanding of litigation, even though I was just working on cases from the beginning. And so I just sort of knew about a summons and a complaint and answer, and then discovery, different motions. Cut to, I left that firm, and then I went to work for a great guy. His name was Bert Rogel. He was my mentor. And, together we handled cases from beginning to end. But by the time I went to paralegal school and then became a paralegal, I worked for an attorney over in Marina del Rey. It was very beautiful on the water. And I would have to get the client ready for their deposition and complete discovery responses. Now, when that happened, here I am owing discovery out. Maybe I've had a few extensions, and I went to prepare the responses and I had no evidence. And I was so confused. So I went over to, I guess, what that would have been called the pre-lit department at that time. There was a secretary, and she was ordering by mail, sending letters and sending, maybe not even, sometimes sending checks for police reports, different evidence and medical records. But then there wasn't always a follow-up. And so I was on my third discovery extension, and that's where I got more involved with pre-lit. And I came to really love pre-lit because the way I work up a case in pre-lit will depend on what the end result of the case is. I mean, we're working in pre-lit, and some of us are paralegals working in litigation. But when the attorney actually goes to trial, which I attended trials with those attorneys, so I worked through the case to trial. And I mean, when the attorney is standing there trying to explain to the judge that, it was a very bad accident and his client's car was towed from the scene, but he doesn't have a tow bill and he doesn't have evidence, he's going to be thinking, darn that Joy, why didn't she get me the tow bill? Why didn't she get it at the beginning of the case? Why didn't she produce it in discovery if it was requested? And that is why I always say, whether you're a pre-lit case manager or a litigation paralegal, please try to attend a deposition, because when you attend a deposition, you will see the reality of the situation where your attorney is being hammered, and the work that you've done to prepare that attorney is, in question and for everybody to see. And when you see the deficiencies, you may want to do different things than you're doing now. So I always ask everybody, I'm a firm believer that everybody should attend a deposition you know, whether you're a licensed attorney, paralegal, or whoever you are that are working up a case. And then Marjorie, if you want, we can go to the first slide. So the first thing I do when I have to prepare the attorney for the deposition is I do review the entire file. Now, some of you will have files that are hard files still. You may have a boss that's my age, or you may have someone who just likes to have paper, or you may be completely online, you may be completely in the cloud. But either way, when you know, I mean, when I worked as a litigation paralegal at Panacea and Boyle that's a big law firm with catastrophic cases in Los Angeles, we had maybe had 25 files at the time. But in the law offices I work in now at Landver Law and Hirschler Law, we have just a few files. So I literally thumb through every piece of paper or every file to read the entire file. I read the correspondence, I just thumb through it just to see what's going on in the case. And I look at the plaintiff's correspondence. I look at the defense correspondence. I look at the things that happened early on with adjusters. I look at the property damage photos, as I brought up the tow bills and the estimates, and I take a look at those. And I actually try to look at them and see what's going on, where the damage is on the vehicle, how much the property damage is. I mean, that's a good point I'm making to myself right now, is that I may want to tell my attorney, the property damage on this estimate is $750 before you go to a deposition. Now, that doesn't stop us from working on cases. The defense will always bring up causation, but it's something that the attorney may want to know, and maybe there was a supplement that was missing and I didn't know that. And so, you know, just different things like that, going through, seeing, is this a clear liability case? Was it disputed liability? What was the situation with liability? Was there comparative negligence, or was it liability accepted? Usually it's not. And then, of course, I read the traffic collision report, see the date, the time, the place. And I'm not studying these things, but I'm just getting for myself a general view of what is going on with the case. If it's a slip and fall, there'll be an incident report. And then there's also, if there are any government reports or the government claims, any government, any correspondence from them. And then, of course, I take a look through the damages, the medical bills, the out-of-pocket expenses, the client's lost earnings and capacity, maybe any documents that they may have given us, like their pay stubs. I just start getting a feel for the case as if I would sit down to write a brief. If there's an if our client was taken from the scene of the accident, I make sure I have the ambulance report. Sometimes you can't have the ambulance report for whatever reason, maybe because the person wasn't transported by ambulance. And sometimes you can find an ambulance report in the hospital record, but you should definitely try to get that ambulance report. It says a lot, and I'll tell you, the adjusters and the defense attorneys depend a lot on the things that happened at the beginning of the accident. And I go through the hospital records, was the client drunk? Was the client impaired? Did the client have other health issues that I would know about? I look at the medical bills, and then I start reading through the litigation, because at some point you have to see what whoever drafted the complaint, or if that was me, just to see what we said in the complaint and what affirmative defenses the defense used when they answered. Were there any motions? And then bringing me to start drafting discovery questions. So That's the thing, is to review the entire file and make sure that you have an understanding of the case, because that's gonna be better than just giving your attorney a few questions that you found from the internet, or, just having your attorney sit there and have surprises at deposition. That's happened too. So that's basically, the first step is to review the entire file. And Marjorie, did you have anything else to say about that subject, or is that helpful to you as well?
It's absolutely helpful to me. I think reviewing the complaint and the discovery would give our paralegals the ability to investigate further, which I know you have more slides on. But this is an excellent start to give our paralegals background on what's going to happen at the deposition and what more they need to prepare their attorneys for.
Right, and these are all things I would have known in the old days, the older days, starting from start to finish. But now there are departments. It's very important that the departments talk to each other, and that goes into the next slide. And that is to speak to the case manager about the case. So if I was the case manager and then I was the paralegal and then I went to trial with the attorney, I knew everything about the case that now I'm reiterating. But now, where actually I actually mostly draft discovery, prepare clients for depots, and draft mediation briefs when I'm not drafting demand letters. So I don't know. I haven't worked on the case at all. I'm just given the demand letter and to go from there. So, I mean, you can give your attorney questions that you found for questioning experts, or you can just tell your attorney where and when to appear and order a court reporter, or you can find out, why did this case not settle in pre-lit? Why are we having a deposition? I mean, if we all agree that most cases settle, 95%, 95% of cases settle, why are we at a deposition right now? I think that's more important than any other thing you can tell your attorney. And I used to be able to do that when I was working on the case from start to finish. Now I have to ask the case manager, and just, what happened in liability? Was it accepted? We just had a case. There was liability accepted, and then a video came out of nowhere that looked like a fake video and like an AI video. And then they now were disputing the case. So like, you'd want to find out, why did they accept liability and why are they disputing it? Maybe send that video to an investigator, before you go to the deposition. Oh, whoops.
Joy, I'm sorry, I lost the
That's okay.
slides.
Well, that's okay.
All right, let me get back into it.
So yeah, so just to speak to the case manager, like, why are we going to this deposition? And that's another thing too. You may want to find out, like, hey, look, what was wrong with your, the case managers may say, this person was perfect, like they didn't have anything wrong. These are all new injuries, but they may tell you that, well, this client was just about to go get scheduled for surgery when they had this accident, and they still went ahead with the surgery. Something your attorney's going to want to know, like, and the attorneys like Marjorie are very busy, just taking depositions and just defending depositions. If you'll go, you'll see they have a lot of moving parts, and the attorney can't focus on every detail, is presumably why they have us. If there were any witnesses and there were any statements that we provided. And then the most important thing, I think, is to tell your attorney, this client makes a very wonderful witness, or this client is going to need some help over here at their deposition. They may not be the best historian. I tell you, when I worked at Panichet and Boyle, the attorney I worked for settled a case. Actually, I'm sorry, he got a verdict of $2 million on a just a very small case. And I said to him, how did you get $2 million on a case that if I was in charge, I would have never let you take? And he said, because the jury loved my plaintiff. And so it was a fender bender, but it caused the person who had pre-existing injuries to be worse. And for that reason, he got $2 million. So it's very important. And just by the way, the last slide where we had all of the different documents, when I review those documents, I personally make copies of them and I make a little cheat notebook. Now I get it if people are paperless or if you have bigger cases where you don't have many hard files, but I keep a small hard file because of the salient documents, like the ones that I mentioned before, because I have to maybe refer to them when other people miss them. So I'm a detail person. And so I've already started making copies of the documents I discussed before, and now I'm starting to either tell the attorney in passing or in a meeting or in an email about the character of the plaintiff and the different documents that I'm seeing. Anything else to add?
Question. We had a question from the audience about how do you handle all of this? And at what point do you find out this information when you have a rather large caseload?
Is that from a paralegal or case manager?
I'm not sure. It's just from our audience member. So
Okay,
why don't you answer it in the circumstances for both positions?
right. So it just seems like a lot and it seems very insurmountable. But in every case, you'll have a police report or an incident report or no report. You'll have hospital records and you'll have medical bills and reports, out-of-pocket expenses, lost earnings. By the time you're preparing an attorney for deposition, presumably you should have all of those documents. So if you're a paralegal, you're going to just make a cursory review of them before you go ahead and maybe inform your attorney about his defending the case, or compose questions for him for experts or defendants. So all of this information should have been gotten in pre-lit. And that's where if you're a paralegal, you'll focus on getting what's missing. So, we need a lot of eyes on the subject. So what I do is if I'm going to go into a file and I'm going to start looking at photos and police reports, I'm just going to press print. I'm just going to 3-hole punch it and put it in a notebook myself, because a lot of attorneys take me with them because I know a lot about the meds to mediations. So I'm just going to, while I'm doing, in other words, I'm not going to review everything and then go back and make copies of it at another time and say, oh gosh, it's 7 o'clock and I have to go home. No, I do everything at once. When I'm reading something, I'm going to take notes on it and I'm going to make a copy of it. I'm not going to look at it. I'm going to rule it out, as they say in the legal field. Did you, Marjorie, have anything to add?
One thing I was thinking as you were talking about preparing in advance, what I used to do when I did not have a paralegal and I was a younger associate is start preparing jury instructions from the very beginning. And that sort of puts your thoughts organized so that you know where the case might head from the very beginning. And I think that will help when you're preparing discovery as well. So some of that stuff will have already been done by the time you get to discovery, which of course should happen before the deposition.
Right.
But you can always talk with your attorney about that and where they think the case is going. But a lot of attorneys prepare their jury instructions at the beginning of the case too, so that it basically creates an outline for where they want the case to go. So that's just one other thing I would add.
And
Have you done that in the past?
Well, so what I do is when I create demand letters, I will take a look at the jury instructions, but I kind of now have the law plugged in, so I don't really have to go back to the jury instructions. But yes, if I am responding to discovery, I may take a look at them. But for sure that's the best thing to do. And that's what attorneys have always said to me is take a look at the jury instructions. Marjorie, do you actually prepare them then, or do you just review them?
I just review them. I'd assist in preparing them if necessary. But if it gets that far in the case, I will assist preparing them and put in my 2 cents.
Okay, all right. So that's the answer. Just kind of roll through everything. It's, just try to, if you have a lot of cases and a lot of documents and a lot of things going for you, just make sure your eyes look at the document or whatever it is, the video once, and just make notes or make a copy and move on. Don't try not to go back in time. Just get a full understanding. That's why I called it review things. You don't have to, it's not time yet to do anything more than review, because you're just sitting down and getting a feel of the case.
All right, we have a pre-lit question. Does a pre-lit checklist work when a case is being flipped from pre-suit to litigation? Have you used that before?
Well, the best thing for me, I've seen so many different checklists, and I would have to see one in particular, but like the documents that we listed on the first slide kind of are a checklist. And so what I usually do, because I'm going into these law firms having not worked on the cases, I'll go into FileVine, and I'll just, more so than making a checklist, I'll review the documents in FileVine because they have different categories. But yes, whatever works the best for you, work it. Because if you have a checklist of documents that you need to have and you've checked them all out, I would, if I came to your firm and you said to me, we use checklists, for sure, I would review your checklist, and then I would come to the case manager and say, hey, why do you have this? Or do we have this? Or why is this missing? So whatever, don't you think, Marjorie, whatever works best for people, they should employ?
Absolutely. And speak with your attorney. Your attorney might have a way that they've done things for a number of years and the way they like to have it. It's best to cater to your audience in most circumstances, especially at trial, but even in the workplace. If you're working for an attorney, it's going to be most helpful for them to do things the way they like it, because they're going to be looking for things the way that they think it should be organized. So if there's a discrepancy with how you want to organize it versus how your attorney is going to want to see it, it's going to be easiest for your attorney, and you should be preparing them to do it their way. Definitely sit down with them, have a talk about it, so you can figure it out from the very beginning, and thereafter it'll go more smoothly.
Yeah.
So we have another question from the audience about, well, it was more a comment, and maybe you could talk about it. What you see when something is missing. I think this might lead into our next slide. But if you see that particularly a good intake or pre-lit hasn't done something, so a good intake is missing or pre-lit has not done a complete job, and the case is now passed to you, how do you proceed from there?
All right, well, let's go to the next slide. I think that's what it says. Oh, right. So you're gonna make sure you have all the evidence. If not, get it. So in that job description I told you when I was in Marina Del Rey, it was a little late to get everything. So when a case is in pre-lit, and then there are some case managers who prepare complaints, compare demands and complaints, but there are other people. But now the case is in litigation. So make sure when a file is assigned to you, you can sit it there for 3 months until discovery is due, but then you can't get all the evidence. The minute the file is assigned to you, take a look through it and see if anything's missing then, and then go get it. So what I quickly do, just say the police report is missing. Now I'm hoping a police report won't be missing by the time it comes to litigation, but just say it is for whatever reason. You didn't, sometimes, I mean, I don't know, there was a police report, I didn't know. What I do is I call the client's first party insurance carrier. They usually have the police report, especially if the person who your client hit is now making a claim against your insurance policy. So I'll go quickly. I'm not going to send a letter with a check anymore. Also, I think you can get like a police report from online, or you can get an investigator. Jump into action, do whatever you have to do to get it when the case is assigned to you, not when you're responding to discovery. Call your client, call the first party adjuster, get the, like a lot of times people will give me an estimate, but then there was a total loss document. I get that too. So I prepare everything fully, and I just jump into action and get it. Social media, or, incident reports for premise, you probably have to file to get those. So you want to make sure that that's in your discovery that you propound. But if you take a peruse at the hospital records, when you get the hospital records, just snap through them, and you see that the client was brought by an ambulance, get those records, ask your clients, hey, did you get an ambulance bill? Or just do the best you can to find the ambulance bill. It's probably the report is one of the most important documents you'll need. And then if any, so the way to get more documents that you're missing is you have to read medical records. If you're a pre-lit case manager, every time you get a medical record, it's not really necessarily to 3-hole punch and put in a notebook or to upload. You should thumb through it and see what's going on in the case. What I do with medical records is, because I used to take a lot of clients to doctors in the early days, when I get a medical report, I'll read the first page to see what the complaints are, and then I'll just read the last page to see what the doctor is recommending, because if I'm wearing my pre-lit hat, I have to get them to the next doctor if they don't go, because the clients don't get their medical reports, so they don't know they're supposed to see other doctors. So definitely when you read medical records, you'll find other records. That's how I always find them when I'm doing demands, but you don't have to wait until you do a demand. You can peruse through them, and you can see, like if you get a hospital record and it says that your client should see their primary care physician in a few days, and you look on their bill and they had insurance, they probably have a primary care physician. Order those records. It may not be something a case manager would do, but it's definitely something you can do at that point, because the insurance company is going to subpoena them. And that's the third thing. You can just wait till the insurance company subpoenas them. I don't like to wait until an insurance company gets my records first. Do you, Marjorie?
No, I would like to know exactly what's happening first, before anybody else.
Right. So that's why I say, if you're a case manager, go through the medical records and bills. If you're a paralegal, same. When you get the case assigned, pick a time, like maybe if you work till 6 p.m. from 5 to 6, and just like go through medical records, just like thumb through them. A quiet time. Don't do it when people are going to interrupt you, or you'll pull your hair out. It's too distracting. And the same thing with any witness statements. Just try to get everything you can, jump into action, because you're going to have to do it anyway. You have to do it anyway. And then anything to add, Marjorie?
So I think that I'd like to add about where or which person is being deposed. So we've had cases where we have experts who are going to be deposed by myself or another attorney. And I think it's really important to look into that person. And even if it is not an expert, look into the officer being deposed, look into the defendant, look into even your client. So that's where social media really comes in. You can find out a lot about a person. We were able to find out things that our client said that we were not aware of. With regards to experts, we were able to find reports that they had authored or articles published that were directly on topic, that had we not looked into it, we would not know their opinion on our case. I think that is extremely important. Almost everything is available nowadays in social media. We know that some firms have a firm account on Facebook, on Instagram, so you can look at what other people are posting. People don't realize what they're going to see when they post on Facebook. People post their whole lives on there. So another disclosure, please be careful what you're posting on social media, because it could come up in litigation someday. Be careful what you put in writing. Look at emails. Hopefully that stuff was turned over to you to begin with, but you can learn a lot about who your attorney is facing just by doing a little Google searching. That's my favorite thing to do. I think as millennials, we were taught how to investigate and be the FBI without being trained. So you have access to it. And most of us have now grown up using the social media or knowing somebody younger who can assist us there. So definitely do your research. It's another one of those things. Look, notice, and do is something I use around my house. Something that wasn't taken care of, just jump on it and do it. It's going to assist your attorney. It's going to make your job easier, because you're going to know something at the end of the day that is going to help the case, or bring something to the attention that brings out an issue in the case, and your attorney is absolutely going to appreciate you for that.
Right, right. That's a good point. I'll leave the social media to you millennials.
And we are happy to do it.
I know.
All right, so we have our sponsors with us, so we're gonna take a brief pause here.
Okay.
And Ginger, who do we have with us?
Well, the first person that we have up is my dear friend Patrick with On Point Legal Nurse Consulting. And if you guys have been watching our webinars for a while, then you've probably had a chance to meet Patrick. And you've also probably had a chance to hear him speak, because he's spoken on a lot of our nursing home abuse cases. And he's been in the industry as a nurse for over 20 years now. They are doing seminars of their own now at On Point, and they're hopefully gonna be coming down to Florida soon, so we could do one for everybody who's going to be here. But they are just an incredible company. Love working with all of their nurses that work there, like Ingrid, Dawn. I mean, I could go on. But Patrick, it's amazing to have you with us today.
Thank you, Ginger. And wonderful presentation, by the way. I always learn something, as I say, every single time I come on, I learn something, and I have depositions coming up and a trial coming up. That's why we had to reschedule our conference in Florida. So I do have a trial coming up starting October 1st. So I always learn some tricks and before I go out there. So again, my name is Patrick. I'm one of the program directors over here at On Point Legal Nurse Consulting and Experts. I've been a nurse for 20 years, and my background started with cardiothoracic ICU at a Philadelphia Hospital, Jefferson, and then I moved out to community health. So my expertise for the past 19 years has been in home health and hospice and long-term care facilities. So skilled nursing facilities, assisted living facilities, and group homes. So those are a lot of the cases that I review. And help with other cases that come in over at On Point. So everything that we do over here, we're a litigation support group. So we help from merit screening all the way up until trials, depositions, prepping for depositions, prepping for trial, looking into the social media accounts, which is always fascinating when we find or we see an expert on the other side and we want to find out some little information, or for a new case that just came over, basically more of a forensic report of looking into everything that happened involving this case. So those are some of the things that On Point can do. We also have 3 certified life care planners on staff. We do a lot of the world famous, as John says, the pain and suffering reports. So we do a lot of those reports, which is a non-economic damage report, and it really paints a wonderful picture of what happened prior to an injury, and then everything that's affected in their lives on day-to-day after the injury. So with all of our nurses over here, we do have a fantastic database of nursing experts like myself. We also have a wonderful group of medical providers, whether it's physicians, MDs, DOs, any specialty we can help you find. There's other experts, placement agencies out there. Ours is a little different because we like to sit with you guys from the beginning of the case all the way through the end of the case. We just don't like to place our experts and then move on to the next case. We're really there to support, to learn about the case. And as a nurse, I love to talk and I love to teach. That's what we love to do. So we're only a phone call or a text away to help you guys out when questions come up. It's better to know the answer right in the beginning, and that's what we're here for, instead of waiting months and finding out what's really going on. So I'll put my information in the chat. We will be rescheduling our conference that's going to be in Florida soon. We will have our conference in Philadelphia in June again. So hopefully when that time comes closer, with the help of Ginger and everyone, we'll get some good information out to everyone.
That sounds fantastic. And I think also what sets you apart, Patrick, from like all these other companies that are out there is that, and all of us, even Laura, I mean, everyone is just so warm. Like everyone loves what they do. And there's so much passion in our work that it's so great to work with people that enjoy what they're doing and they're helpful, they're responsive. So we love working with you guys, and we appreciate all of your support here at Connectionology.
Well, thank you. And hopefully I'll see you next week in person.
I hope so. All right. Well, on to the next one. We've got Miss Laura here with us with HMR, and another fabulous company who's been with us for many years now. I know you do a lot of work, Laura, with John Romano, Nancy Romano, the entire law group. Marjorie, I think you're very familiar with HMR as well. But Laura, it is awesome to have you. We have missed you very much, and we were excited to hear all the great things that you can do to help our attorneys and our paralegals who are watching today.
Thank you for such a nice introduction. I'm really enjoying Joy's presentation, and Marjorie as well. I'm going to steal your intake to trial title that you had at the very beginning. I feel like that sums up what HMR does perfectly. HMR servicing is a funding resource strictly for your personal injury cases and your case needs as a law firm. We do everything from intake to trial. And by that, I mean, we are funding those medical needs, those catastrophic case needs, if you will, cost of living needs, as well as when you are preparing for trial. Maybe you were going to settlement, now you're going to trial, and you need expert life care plans, you need wage loss, you need all of those things. We're able to stick with your personal injury claimant. To us, it's a patient. I know it's a claimant to you, but to us, your claimant really is a patient. We're trying to do everything possible and leave no stone unturned with their care plan. Most people don't realize that most of HMR servicing medical funding is interest-free. There is no interest on those expensive medical surgeries and traumatic brain injury rehabilitation stays, burn care, you name it, any of those really complex needs. You may have, as a law firm, you may have solutions that work day to day. But when you get the case where nothing can be not tended to, every little step of the way has to be accounted for, and there has to be continuity of care. And what happens when you think it's a spine injury, you find out it's actually a brain injury on top of a spine injury, and now you need a neuro-ophthalmologist. That neuro-ophthalmologist says you need a cranial osteopath. Those are the types of cases that we really do shine and try to deliver. When you work with HMR servicing, you're getting a company that really prides itself on relationships. And we can't do that if we don't have excellent communication. So I try to liken our process to a game of tennis. Every time you have a need, we're finding a solution. We're asking you if that solution is acceptable. Is your client happy with that solution? We then move forward. We fund that. We come back to you with what that provider says is needed. What is the next step? Where are we now? Do we need imaging? Do we need blood work? Did we fund a surgery and now there's a hernia issue? We're in it to see your case through from the beginning all the way to the end, to when you might need something for your trial prep to help you get that case across the finish line. So when you work with us, you do truly get a team that wants to take on your toughest cases. We want to keep you in the loop and have ongoing communication. And we want you to have a successful case outcome where we've been a part of proving those damages, helping build the case value, and taking care of your client in the process and making sure that they are number one and first and foremost. So I will put my information up. And if anyone ever has a question, we underwrite all of our cases through our attorney portal. It's a free process. We spend the time and energy and dollars to underwrite your cases and answer any of your questions that you have. And that's before we even get started in funding one thing. We are doing all of that work ahead of time to make sure that we can be a part of your case. So I thank you. Thank you, Ginger. Thank you, Joy and Marjorie.
Yeah.
Absolutely. It is always a pleasure to have you with us, Laura. And I learned so many more new things just today, you sharing that. So thank you so much.
Yes, absolutely. And not to interrupt you, but we're giving you a liens list whenever you need it. We include things that we don't fund. If we find out about a lab bill, we put it on our list. So we really give a template to you as we're going. You see everything. So it's a really neat process. Thank you
Oh,
again.
that's perfect. And if you could definitely put your information in the chat box, I want everybody to stay in touch with you, and especially if they have any questions. I want to make sure they have a chance to reach you.
Perfect. Thank you.
All right, we'll see you back here, I hope soon. And now I just wanted to remind everybody, feel free to keep your questions coming in. We are keeping an eye on those on the chat box and the Q&A box. And I think, Marjorie, there's one in there right now from Miss Joy. And then we'll be able to jump right back into the presentation.
Thank you, Ginger.
Thank you. This has been great. And I love seeing everybody's questions and feedback, because we were talking about that, Miss Joy. This is like the best chance to be asking questions while we're all here together.
Yes.
Mm-hmm.
100%.
And it looks like this question comes from Joan. When do you think a case should be put in litigation? I feel something as a litigation paralegal, we get cases to put into lit too soon before even having all the fundamentals taken care of. And that includes clients' documents, liens, medical records, and bills, a demand sent out. What do you think about that?
Well, I'll tell you for me, and Marjorie's going to have a different take on it, but and usually it's the attorney. When I work with an attorney, the attorney will decide. Of course, I'll nudge them. But with me, when have my pre-lit hat on, and I see that an adjuster is exhibiting bizarre behavior, is angry or not understanding the case, I'll recommend to file. And that doesn't mean that we're going to go to trial. It just means we're going to file a lawsuit and get rid of the adjuster that's not understanding the case. So in that case, I don't mind if I know I have to file. Sometimes when we file, we'll get an offer. Sometimes when we file and serve, we'll get an offer, because now we'll get a defense attorney on the case who says, hey, look, just settle this case, and then the insurance company will listen. So don't stop yourself to file. If you've come to the end of the road with your adjuster, don't argue with your adjuster and put in writing all of your thoughts about liability and damages, because those are for the experts who just spoke. Just file the case, but know that you may not have to do much more on the case. And then just go ahead and get your documents during the case, during the litigation. Do the best you can. What did you say, Marjorie?
I think if you see things that aren't done, I'm one of those people who will just do it myself. But if you see a systematic thing that's happening, talk to your attorney. That's the best advice I have. Talk to the people who are making the decisions, who have the preferences that you need to live up to. So that's all you can really do. If you see things that aren't to your liking, you make the changes. You continue to investigate, because if you're going to be held responsible for it, then you need to take action. And I think that goes right to your presentation, Joy. When you see something is missing, get on it.
Yeah.
All right, are we ready for the next slide?
We
can go
sure
there.
are. Thank you
Now
both.
I've had my water, we'll go. Okay, so that's another thing is, especially somebody brought up a great point, you have a lot of cases. So I don't like to do things too many times. So when I draft discovery, what I will do is I'll get the discovery out to the clients. Of course, they won't know what it's talking about. And then I'll create shells. I'll start making sure I have all of the documents I need or start ordering them then. And then when I start drafting, what I'll do is I'll draft discovery responses without the client. I'm not going to call a client into this conference room and ask them what is their name, how many names do they have, what year were they born, which city. I'll try to figure out everything through the file. When I'm done with that, I'll have the client come in, or I'll just Zoom with the client to do the rest of discovery. And that's when I start prepping the client for their deposition. Now, you may say, Joy, why are you talking about discovery when this is a deposition chat that we're having? But that is another great way to help your attorney. When I start with the client, I'll send them to discovery, I'll have a chat with them, then I'll have them in, and then maybe prepare them again. By the time they come and the attorney prepares them and they do the deposition, the attorney comes to me and says, wow, that was a great deposition. The client did so well. I can't believe it. And I say to myself, well, I can believe it because I prepped them 4 times. So that's another really great help you can have when when you're working with clients. And then of course, always telling your maybe sending emails or chats with your attorney to tell them what's going on in the case. And of course, they're going to see your discovery responses, but just point out different things about the case you might see. And then another thing I'll do is, so when I ask the client, how do you feel? And the client says, I'm fine, but my leg hurts. And I'll be like, well, I know you're telling me you're feeling better, but at your deposition, please say, my leg hurts. I mean, it's the human condition to want to move past bad events and feel better, but you can tell somebody what is wrong with you, and just to listen to the question in your head when you're at your deposition, and then answer the question the way they're asking it. Now, it depends on the case. If this is a case that I think could be settled, or I want it to be settled, going back to the last caller's question or the last chatter's question, if I think that the case can be settled, I'd like the client, if they make a good witness, to give more testimony. If I know that the case is going to trial, maybe just, I don't know, I don't recall, yes, no, and just a few sentences here or there. So I'll prepare the client according to how I think the case is going to go, to try to settle the case, to give more information. And then if the case isn't going to be settled, maybe to give all the information, only what you're asked. And if the client, unfortunately, I have had clients tell me that they've done things that weren't things that I would want them to do in their case. You have to tell the attorney that immediately, because maybe the attorney will just settle the case before a deposition. Also, if you can always tell, what I tell the clients when I prepare them is that the truth is the best lie. If you're thinking about what to say, or not that anybody's lying, but just tell the truth. The defense attorneys are very experienced, and they can, just like I've talked to people for many, many moons, I can see when things aren't adding up. And so when things aren't adding up, I just tell them, please just tell the truth. But I also have them discuss it with the attorney, because the defense attorney is not, they have had your demand letter. They have all of the discovery you've sent them, and they have all of the documents. They're coming to the deposition to see if your client is credible, meaning likable, if they can explain what happened to them, truthful and sympathetic. And so you want to let your attorney know if you don't think your client is being truthful, credible, sympathetic, or is a poor historian. You know, you want to let the attorney know. And not to try to, I tell the clients, please don't try to, you know, prove your case. They're sometimes mad because their insurance company has paid out their policy. They had a small policy and there's comparative liability, but not to argue and just to dress like business casual and just to conduct yourself like you're in a, you know, going for a job, you're in a job interview. And at the same time that I do all of this, at the same time that I'm responding to discovery and making copies or putting together a PDF of evidence, I put that together now, and those are the exhibits not now, I put them together at the time, and those are the exhibits you can use at the deposition. They are the exhibits that you're going to attach to your response to production. So just try to do, because we're all very busy, again, try to do everything at once. When you put your hand on it, process it and move on. Every document that you will receive requires a response or an act. They're not to put away in a file for another time. And if you deal with, you know, just kind of like you're at a batting cage and you're just hitting balls as they come. And I think that's the best way to process things, especially for people who are busy. What do you say, Marjorie?
Completely agree with you. Efficiency is the name of the game in litigation. Do it once and do it right.
Good. All righty, well, we can then move to the next slide. Oh, there's the investigators. So, right. Again, now, you've gone through all of your files, presumably. You've met with your client and drafted discovery, or somebody has. You've read through all of the discovery documents, including what, you know, it's also important if the defendants have answered discovery to review those. That's important for both the plaintiff and the defendant's deposition, because now you're done trying to prove your point and you're seeing what the other side is saying and what their point is. So now you're trying to figure out, why am I at this deposition? Why didn't this case settle? Maybe I don't want this case to settle because I think we have to do more treatment or go to hire experts, and we have to kind of move the case along. So now you're going to do more of an intermediate or an advanced analysis of the issues of why you're at the deposition. And then, you know, now you've pretty much seen your client's character and past records. You can, all of the insurance companies do the ISO, they check your client's background, and I think law firms should do that as well. You know, it's always best to know if your clients have been in past accidents or have had past injuries, because then you can discuss what happened in the past with them. So I had a client who had 6 accidents. None of them were her fault. I don't know how she had 6 accidents in 4 years, but I found out about each of the accidents, not through her, through ISO. And then I asked her about them. So out of the 6 accidents, none were her fault. 2 were fender benders where there was property damage only that was fixed. And then the other 4 were different injuries. But at least when the adjuster or the defense attorney calls me up, and sometimes they do, and said, hey, look, Joe, I like your, you know, I know your boss wants this amount of money for this case, but your client's been in 6 accidents. And I'll say, well, not true, because 2 of them were, you know, fender benders, or when the car was parked, it was just property damage. And the other 2 were minor injuries. And hey, I spin it around. That's why they're more injured. I mean, how would you have liked to have been in 6 accidents? But the key to that is that you didn't cause. So the fact is that if the client didn't cause the accident, you know, they're getting into accidents, they're getting hurt. Like, they're getting injured in these accidents. And so their injuries are not a fault of theirs. They're something that happened in the accident. And you just work on all of the cases and just, no, I'm not going to hide injuries that the client has because they're in medical records and other records, but I'm going to show from case to case how that client's injuries got worse. So for example, the first real bad accident with the biggest property damage, the client got really badly hurt, but she had been done treating by so the first accident was a fender bender. The second one or the third one was pretty bad. The fourth one, she was done treating and her injuries were resolved. So of course you want to figure out, like, is she worse now from the accident? And I always ask my clients who have had several accidents or have pre-existing injuries, I know that you had some treatment for your back. What was the difference of your back pain before and after the accident? And I always go deeply into before and after, to figure out where we are today and how we got there. So I try to figure out those. I try to figure out more about liability, meaning, yes, I know we're still in the discovery phase and we don't need to have we don't need to start working with expert witnesses, but you know what? This liability is disputed. We're saying it's not our client's fault, but we're not experts. The defense is saying it is our client's fault. Why not send out the information, if you haven't already, maybe to a liability expert and get some more information on liability now, so that you can advise and of course, all of this you work with your attorney or your attorney already does it, or you make the recommendation to your attorney, let's just stop fighting. Let's just get an expert and find out what is going on regarding liability so you can rule it out and you can move to the next episode. Before we at Landver Law, before we sign any premise cases, I call up a premise expert and I ask the premise expert what they think about the case. When the premise expert gives me a thumbs up or a thumbs down, I ask them why. When I ask them why and they tell me why, I put that in my demand letter. So for instance, I may think that the plaintiff slipped because the handrail was faulty, but my expert may tell me, no, the plaintiff slipped because that was the wrong type of tile to use in front of the apartment building. So when I write my demand letter, I'm not going on and on about the handrail. I'm writing about the dangerous tiles. And then of course I get a call from the adjuster saying, what do you have, an expert? Or the adjuster, or sometimes the defense attorney, what do you have, an expert? And I'm like, don't you? Because the insurance companies, they have experts or they have people on theirs that work for them that have expert knowledge, and they've already decided what liability is. If you write a demand or if you answer special ROGs with the wrong liability, you're going to have to go to trial on that case because they can see you don't have an understanding of the liability. But if you know a few sentences about your liability when you respond to special interrogatories, that you can put that information in, and you can let your client know at the time and the attorney know as well. The issue is with the tile, that was the wrong tile to have put at that property. And furthermore, it's different tile on the side of the building, which isn't as slippery. So the apartment building knew or should have known that they should have put less slippery tile in the front of the apartment building. So things like that. So I start more nailing down issues before the depositions so that the attorney knows where they're going with the depositions. And, even if they're taking the defense depos, the questions that you submit to your attorney for the deposition of the defendant in a premise case are going to be a lot different if you've spoken to an expert, because the expert's going to get, and that's another good point too. if you do hire an expert because liability is disputed, but you think you have a good case, in that case, you may want your expert, who you already now have retained, and you can use the company that they just, let me see, I just wrote their name down. The company that just spoke. Let me see, I'm trying to see it, so I know their name was H. Do you know their name, Marjorie, the name of the company who just spoke?
MR servicing.
The one with the initials?
Yes, HMR.
Okay, so that's a good thing. So if you are seeing, wow, I need to hire an expert, maybe you can work with HMR services and they can help you to fund your case, because unless you just want to check out of your case because you don't have the best client and you don't have the best evidence and they don't have very big injuries. But if you have a good case, you may want to get with a company like that right away and start working with them and getting funding to hire an expert right away. Even you don't have to disclose it yet, but you could start, and that'll get you closer to settlement, in your cases. And then, of course, prior claims we discussed through ISO, or you can ask your clients. It's very interesting because sometimes I'll ask a client in discovery when I'm doing discovery responses about prior claims, and then they say no, but then at their deposition, when they're sworn in, they may answer differently. And so for that reason, it's interesting. That's why I always like the clients to fill out discovery before they go to their depositions, because then the lawyers like Marjorie is going to go charging out of the room and said, hey, this client had prior accidents, but when you responded to discovery, you wrote no, and I relied on that information, and now I'm in a deposition and there are prior claims, and you can tell your attorney, I spoke to the client, here are the client's responses, here's an email saying that they had no prior claims, and then the attorney can handle it directly with their client. So yeah, was there a question that came up, Marjorie?
No questions on that one. I think everyone's in agreement. So I move to the next slide.
Okay, good.
And let me get your thoughts. How do you approach your attorney when you come across issues?
So it just depends. Like in both of the offices that are taking up most of my time were small offices. So usually we usually have case meetings. And during those case meetings, I'll approach them and tell them different things. I once had a little bit of a problem. I went with an attorney to a deposition in Long Beach, and I forgot to tell the attorney that the client had been taken out of high school and put into continuation school for smoking marijuana. This was maybe 20 or more years ago, so it wasn't legal then. And I was sitting during the deposition and I forgot to tell the attorney, and they asked the client during the deposition where he went to high school. And then I kicked the attorney and she said, ow, ow. And she started rubbing her leg during the deposition. I'm like, please, let's go outside.
Call your attorney. It will not go well.
Right. And I said, please take a break. And she was like, ow. And we went outside and I was like, I forgot to tell you, there was continuation school, which is, it's okay. Nobody's perfect. There's nobody perfect out there. But the fact is you don't want to be kicking your attorney under the table at a deposition and them start screaming, ow, ow. So
that was not in the record.
How would you, it may have been something that I ordered. That's another thing. I ordered the school history for some reason. I guess he was a young guy, but how would you, Marjorie, would you have liked me to handle something like that? Do you want emails, chats, or what do you want? How do you want to find out?
I always like an email. One of my favorite paralegals in the past who has since retired, she would make a narrative for me to read. So everything was in order and I could find out everything at once. If anything was ever forgotten and she was with me at a deposition, passing notes is just fine. It's still between us, so it's protected. Nobody needs to know that you forgot anything. I would also prefer to not be kicked during a deposition, but if it's extremely important and I'm not paying attention, I guess that's the only way to get it done. But nowadays everything goes to a smartwatch or we can take a break. There's plenty of ways to let your attorney know. We always prepare with a binder here. I prefer everything online. I can take an iPad, I can take my computer with me. So I prefer not kill a tree unless it's extremely voluminous case that it would be more helpful to have it written down. But again, talk to your attorneys. There's what they want to know what they like best. Cater to your audience.
Right. And that's what you're doing. You're just trying to get the information for the attorney prior to the depo. So the attorney can, sometimes if it's the kids laugh when I say this, it's a bad scene, man. And then my kids laugh. But sometimes if it's a bad scene, man, the attorney may not even want to have the deposition after you've told the attorney things are not going well at all. And I'm not sure about any of these things that we're talking about, and the attorney may call and settle the case before the deposition, because we also don't want people to have depositions that are, are problem for them. I mean, we don't want to give them any problems about certain things that may not be above board. So it could be, in this case, the best interest, and the attorney will explain to the client that it was in the best interest to settle the case. And it's interesting because by the time the attorney does that, my clients are usually above board, because I've had a chat with them saying, well, that is, this could be a problem, and maybe going into whatever problem they're identifying with me and kind of talking to them about it. So by the time the attorney speaks to them, they're already like, I get it, I see. And then the attorney tells them, I'm just going to settle the case. So also for me, it's like a precursor with them to kind of get them ready for whatever is going to happen in the case too. So, that's another thing. And that's another, coming to the next slide, which is, of course, if there's anything in their personal history. We had a client who answered in discovery and at his deposition that he was never charged with a felony, but the defense attorney had information on felonies with him. And the co-counsel trial attorney who he partnered up with was pretty upset and said to me, you answered no, that he didn't have any felonies in his discovery, and now he's answered no, but the defense attorney has just sent felonies over, and we have a real problem in the case. And it was sad for me because I worked on the case for so long, and this poor fellow did have legitimate injuries. He also had substance abuse problems, and he was trying to overcome them. But when we spoke to the client about it, he said, I didn't know they were felonies. I thought they were misdemeanors. I think they were wobblers. That could be misdemeanors or felonies. So he clearly spent maybe a little time in jail and got out and wasn't aware that they were felonies. So, so that's why with the person, I guess, was it on the past slide there, I think. We were on the slide, right? So, are we running out of time, Marjorie, or are we good?
So we have about 15 minutes and we do need to take a break before our next slide. We have a few more sponsors to introduce.
Okay, so should I finish with this slide, or do you want to hold off there?
Yeah, let's hold off here. Well, are you finished with the slide?
Well, I could go into it a little more if you want.
All right, so let's finish this slide and then we'll turn it over to our sponsors.
Okay, so that's the personal history. It's usually criminal background, something like that. The school history I described with the educational history. And that's when I found out that the fellow was in continuation school. Work history, we like to get our clients' employment records. So in that case with the felon, we also got his employment records, which mentioned things about the felony. So we took his lost earnings claim off the table. We didn't want to produce the lost earnings records. So we said, hey, look, we're not making a lost earnings claim. And we explained to him, we can't produce these records. You'll have to forego. He wasn't making that much money anyway, so it was okay. Social history, I think Marjorie went into social media. Medical history, you're always going to want to let somebody like Marjorie know problems that they had before, whether they were just born with them or accidents. I've had a few clients with Chiari malformation that they were born with, but we always check out if they seem to have been made worse. And that's another thing too. I like to ask about hobbies because for the company that spoke earlier, Patrick will do general damages for pain and suffering. And those, when you see those really big verdicts, they're for general damages for pain and suffering a lot of the time. So I always like to try to find out hobbies that the client could and couldn't do. That's something I tell Marjorie, hey, look, like we have one client and he literally doesn't work out anymore. But you have to be careful to tell your client if you've ever been working out, there could be video of you. So don't ever say never unless you really never played golf again. Don't say you never play golf. Just say it's difficult to do. And those are big ticket items for their hobbies. We discussed prior and subsequent accidents. And to put it in an email or to discuss with the attorney, Marjorie likes emails, and then I like how her last paralegal prepared a document for her with everything in it.
All right. So let's take a quick break and turn it over to our final sponsors.
Absolutely. And Joy, this has been really great. I love hearing all the different things that you've been teaching us, and I love seeing the questions that have been coming in. I am going to quickly introduce one of our great friends. His name is Nathaniel, and he's coming in with Fox AE, which is an amazing company. I probably am at the point where I don't even need an introduction anymore, Nathaniel, do I? Because what you guys do is so amazing. Your animations, your graphics, there's the demonstratives, like these are the things, like if you have an idea, someone can come to you and you will make it happen. You will create it. It's been very, very well received across the country, all of the work that you guys do. So we're happy to have you with us.
Yep, glad to be here again. It's been a little bit, but again, thanks for having me. So a little bit about myself. I'm the VP of Operations here at Fox AE, and I've been working with Cody for a little over 7 years now. So it's been quite the ride with him. But yeah, as Ginger said, we can do animations, we do graphics, still shots, we can take your PowerPoint, add some of our graphics in there, tweak it here and there. And we do a wide range of different things. We can do medical, we can do surgical animations, injuries, accident reconstruction. We do some construction as well, although of course personal injury cases is our biggest one. So if I can just take a moment to share an animation that we recently finished. And this poor gentleman went through a lot. And as you can see here in a minute, you'll be able to see his overview of all of the different injuries he had. So he had brain and facial injuries. He had a right wrist and thumb injury. He also had a left wrist injury. And then he had a left leg injury as well. So what we do is we kind of present it all up front and show all of it together, but then we dive down into the different ones. And so here, as you can see, we are taking the MRIs of the brain and reconstructing all the blood clots, all the hemorrhaging in the brain that we worked alongside the expert with to reconstruct this. What we do is we have either the expert give us some of the MRIs with circled areas where the blood is, or we do have medical staff on our team as well, which they have tons of experience with. So we either have them draw it or we draw it, and then we send it to him for his verification, and then we make tweaks or whatever the expert needs. So here's some of his facial injuries, lots of cuts, bruises. And then we dive into the different sections. So here we're diving into the right wrist and thumb area. And so we show the location of the injury, and then we make that fracture happen and show all that gross texture there. And we also like to include the x-rays, the scans directly alongside the fractures as well. That way it gives it more credibility, make sure it's accurate, and even the viewer can see that it is relatively and overall accurate. And so this one is basically a breakdown of all the injuries that this poor man went through. But it's so powerful just seeing all the different injuries going one by one. And then, as you can see here in a minute, we bring it all back together and show all of them in one. And then we also show his chronic pains and stuff he has to live through for the rest of his life. And when we can, we overlay the exact x-ray and show how exact and accurate it is. And then this right here could be a still shot for you, just all the different injuries in one spot. So we love to work with anyone, and we have done tons and tons of animations, illustrations, whatever you can think of. We could probably do it if we haven't done it already. So thanks for having me again.
I'm willing to say it's not probably, Nathaniel. I think you definitely can because you
Yeah.
guys are definitely, you think outside the box. The animations are incredible. I believe John Romano is working like exclusively with you guys because your work is that good. And not just that, but y'all's attitude is just amazing. So it's a joy to work with you guys. I see that some people are already asking for your contact information, so please put that in the chat box. And then I would say if anyone watching has more questions, you can definitely reach out to Nathaniel, but go check out their website and then also check out Fox Prime, which is kind of like Amazon, but it's like Fox Prime. You can like get it right away if you need something quick that you don't want to wait for. They've got a lot of other great graphics and things that you can use on that website. So it's pretty cool.
Yep. Thank you. Yep. I'll add my information, including the website, to the Prime website.
Thank you. All right. We'll see you
Thank
soon.
you. Yep.
And now, my friend Charles, it is amazing to see you with us. I know we usually see Jonathan or Aaron, but everybody's traveling to Nashville this week for a very special program. So they're bringing in their best people. And Charles, it is wonderful to have you with us because your company is dealing all with like AI technology. And enjoy. This is really cool. If you've never heard about this company, it's just the stuff they're doing is unreal. That's all I could say. But it's great to have you with us today, Charles.
Okay, great. Are you doing my slides or you want me to do it?
I will go ahead and share them for you right now.
Okay, great. Joy, you used a couple of good words here during the day. You used the idea about credibility and trustworthy and believability, and we actually show you all that stuff. So Emotion Track, we are a legal tech company. Our tech has been under development for about 4 years. And what we are trying to do, or not what we're trying to do, what we do is we actually get beyond this statement of helping attorneys discover what people think about their case. We actually, I don't have animation here, do I? There we go. We help attorneys, go back one. We help attorneys discover what people feel about their case, not what they think about their case. So that's the big difference, because everybody says, oh, we do a focus group and they thought, or I think this and I think that. And we're just trying to change that to say that I know that people feel like this when they see that, or I know people feel like this when they hear me say that. So that's where we're trying to get to. And go ahead, Ginger. And you all know this gal, right? So this is the science. Mona Lisa, I've seen her 3 times. I've met her 3 times. I don't know if anyone else has met her, but I've met her 3 times. And, you know, people over 400 years have been writing about what her feelings are and what her emotions are and what Leonardo was trying to portray. And we now know that. So we've got the science to tell you what she's feeling. And that's important because we make our decisions based on emotion, and then we support that decision with reason. Go ahead. And one more, and this is written by Jerry Spence. So everybody's heard these types of phrases that 90% of communication is nonverbal. And go into the graph. So this is the secret sauce that we have here. And what Emotion Track does is we will show 100 people an attorney's opening statement. And we challenge the attorney to make the opening statement in 5 minutes, which, as you can imagine, blows their mind. They can't possibly make an opening statement in 5 minutes. They're used to 45 minutes. They're used to 50 minutes. They're used to an hour. But today, guess what? There's 5 generations of Americans listening to their case. So nobody wants to hear 45 minutes, honestly. Ginger, go to the next slide. So what we do is we show that opening statement to 100 people, and while they watch it, we record their facial expressions. And while we do that, we are analyzing their facial expressions for their emotional responses. So here's a set of emotional responses on one of the maps that we show. And as you can see, there's a mean line in the middle of that green line. So if I was an attorney, forget what emotion this is mapping. But if I was an attorney and I was looking at that, I would say, hit the button there, Ginger. I would say, oh my, I have a difference between pink and blue, don't I? I wonder what the difference between pink and blue is. And pink being women in this case, blue being men in this case. So think of it this way. If there's 100 people on this call right now, then we take 100 EKGs and we render them together simultaneously. So what we have here is this pink line represents 50 women, and we have taken their emotional expressions determined by our science, and we've amalgamated them into one chart. Let's go to the next slide. So this is a different map. And there's 4 maps that we show. This is a different map. So in this map, you can see there's still a pretty big difference between men and women, blue and red. But look about 2/3 of the way in when you see a picture of the plaintiff, 2/3 of the way in, young woman, nurse terminated wrongfully. So at 8 minutes and 20 seconds into this video, the men and women are almost perfectly aligned in their anger at the defendant. So what the attorney gets to do here, the attorney gets to watch this map and look and see where and precisely how they are agitating the plaintiff, the potential jurors, 100 people. And so while there's plenty of ways to trial consult and jury consult, we're just simply going to show you. So we're going to show you where, let's go to the next slide. Oh, me, oh my. Let's go to the next slide. So what? Well, if you know what the correct emotional trigger points are, because you've determined them by working with the science, and if you know what the evidential caca is, and if you actually practice your storytelling in front of a mirror and then send us the video, well, here's what you got. you're going to win more money. You're going to win more of your cases, and you're going to know what the bombshells are that you're walking into with your case presentation. And Joy, one of the best things that comes out of this exercise is having an attorney make a video, because they don't do that by themselves in front of their computer. And I will tell you, I've had attorneys give me 9 different videos before we tested one. And I've had attorneys struggle and struggle and struggle and struggle with their narrative. At the end of the day, if they do the work, they're going to get the best opening statement they've ever made.
That's
And
great.
that's the end of that presentation, Ginger.
That's great.
And if you can, I mean, it's amazing what you guys do. I need to do another webinar with you soon, Charles. But if you could put your information in the chat box too, so that way everyone can reach out to you guys. And then again, this is another website you should definitely check out so you can find out more information. But this technology is just, whew, this is going to be the future. So thank you for everything so much, Charles. And thanks for being here with us today.
You're welcome. Thank you. It's great to get a look in the world of paralegal, since you're the ones that are doing all the work.
Absolutely.
That's right.
All right, Miss Joy. Well, I'm going to go ahead and bring it back with you and Marjorie so we can finish out your presentation. And then if anyone, again, has any questions, now's the time to bring them in, okay?
Okie dokie. Well, here we are at, do you want this case to settle? Meaning, do I want cases to settle? Sure. I may want them to settle for different reasons, but do you think that the case, would the attorney want the case to settle? And that's when you prep your client, and that's when you find out information that you may be more forthcoming with if you want the case to settle. And then, right, so if a client is still treating and it's hard to know what the future medical expenses are, maybe you don't want the case to settle right now because the future medicals, which are a big ticket item in the settlement, are ongoing. And that's another story too. Sometimes we have accident cases with accidents that are still going on. And sometimes those accidents, they kind of they may be, if they're just a few months between each other, they may all relate. So you may not want to settle the second case first before the first case, or vice versa. Those are attorney calls, but you would just want to know if you're going to this deposition to settle the case or not, and just tilt your whole, as we discussed in the other slides, just tilt your whole analysis of the case to if you're trying to have it settle after the deposition, if you're going to go to mediation, and if you want to max your case. That's pretty much all. Anything to add, Marjorie?
Nothing to add, but we do have a question for the audience that might go back to previous slides. So how do you investigate if your client has claimed lost wages and they haven't filed tax returns in a couple of years? Have you dealt with that situation and what you would do to prepare your attorney for deposition?
Yeah, that's difficult if they haven't filed. And I know that different attorneys handle things differently. Some attorneys said to me, doesn't matter if they lost time from work, you can maybe have a person who writes an email saying that I paid this person this and this amount. But for me, if the person has been paid cash or maybe hasn't filed tax return, it's difficult. But I'm going to leave that question more to you, Marjorie. How do you handle something like this?
Well, in the deposition context, if it's our client, and again, this is going to lead to our next slide about who is being deposed.
Right.
You'll want to talk about what they could have earned. You want to talk about their education. So you want to prep the client. And I know we're going to get to this later. I think prepping your client to respond in a deposition is going to be pivotal. Even if they don't have tax returns, find out why. So you're going to want to talk to your client and find out everything you can about their financial position, why they are claiming lost wages. Maybe we want to get an economic expert in there, or somebody who can speak to their career choices. But ultimately, it's going to be an investigation into their past. And again, motive is definitely going to help us in that circumstance. So you can speak with your client as the paralegal. There's probably been a discovery question on it. So you'll probably know what their position is at the point where we get to a deposition, but if not, find out their background, their reasoning. And then if you're not going to prep your client, if the attorney is going to prep their client, make a note that you think maybe that there is going to be an issue with regards to that because there are no tax returns. If they just haven't been filing them, it's a different issue entirely. So I think that is just get everything you can and proceed. And as you've mentioned in the past, Joy, let your attorney know in some way, whether it be the email, the narrative, or you've just flagged that question in discovery. But I think that does speak to the next slide for you, which is the attorney defending or taking? Who is being deposed here?
Right. So if the attorney is taking the deposition, there are different questions, for lay witnesses or expert witnesses. As I mentioned before, we get our experts to write a lot of questions if we hire them early on. And right, so just you can go on the internet and get internet outlines for your attorney to depose an expert, but also to have your attorney ask questions pertaining to the outcome of this case. And then if your attorney is defending his client or her client, you would just tell them, like we said before you get to the depo, about problems, and you guys can brainstorm together and work on it and have a successful outcome for everybody. So yeah, so that's basic. This basic slide is what we were discussing about how Marjorie's paralegal prepared a document for her, and kind of a recap, get some information over to the attorney, try to jump into action and obtain missing information. Sometimes I've had the client themselves go to the hospital. I mean, sometimes they get mad and yell at me, but other times they go and get me documents I'm missing. And then everything leads into everything else. The pre-lit is what you're going to review, and you're going to then prepare your client with that knowledge. And then you're going to prepare your attorney with the client information and the pre-lit workup. And then, but your case isn't going to be done because most of the time you're going to a deposition and then going to go to a mediation or go to trial. So you can make notes going forward. Also, I like to sit through depositions and hear the questions that the defense asks. When I know the issues and then I see the questions the defense are asking, I can see what is the money, what is going to make me money in the case. If they just dwell over the person's tennis career that they never have, we have to discuss that. If they talk about their health or liability in the case, we know we have to focus on that going forward. And then that's how you can prep case strategies going forward by narrowing down the issues. And then, of course, I think everybody should at least, it was eye-opening to me when I went to a deposition and watched what was going on. I completely changed the way I conducted myself prior to the deposition, because it wasn't pleasant for me, right, Marjorie, when you're sitting there and stuff comes up, it's not pleasant. And only if you're sitting there and you can feel the burn of you doing certain work or not doing certain work is only when you're going to change. So I would recommend to go just attend depositions. If, sometimes I go to depositions and I draft demand letters, but I just listen with my other ear, or other times if I can't go to the deposition, I have the client call me and tell me what happened. And, I always tell them before, let me know like what question they keep asking you. And then I go to try to work on that, to max the case going forward.
And with Zoom being so accessible to everybody, for the most part, most depositions I've done recently, we've let almost everybody into the meeting if you're with the same firm. So there's usually not an objection to a paralegal sitting in.
Right. Friday. And there's the puppies. And
They're so cute, Joy.
those are my grand dogs. Nala, Cassie, and Blue, and they're left at home without me for many hours, but they understand I have to work and they have other people at home that they play with, and they're super fun. And so if you hear them barking in the background, if anyone has any questions I do consult with a lot of different attorneys and law offices, sometimes baby lawyers is what Alina calls them, but they're not baby lawyers, they're just starting out. I do consult with people and tell them how I feel they could get the most recovery for their case. And that's about it.
Well, this has been fabulous. I have enjoyed it so much and I've learned so much more. Miss Joy, I hope you will come back. And Marjorie,
Thank you,
it was
Jen.
just great having both of you guys together.
Yes.
Thank you for
And-
having us as always, Ginger. And thank you, Joy. Wonderful.
Thank you. Wonderful to meet you. I guess where will we see each other next in Texas?
Hopefully in Texas. It's coming up. It's less than 2 months away now. And it's
Oh,
going to be our second annual Depositions or Trial Seminar. And it's actually pretty cool this year because we've added some new speakers. It's going to be in the Stockyards, which is a very, very cool place if you've never been. It's like maybe 15 minutes from downtown Fort Worth, but it's like, I don't know how to describe it. It's almost cooler than Nashville, if you can believe that. It's where they do the bull riding, the PBR bull riding, but it's an old town with antiques, great shopping. But the reason why we're all getting together is because we've got John Romano, Satch Oliver, Joe Freed, Christian Miller. There's just so many amazing, Philip Miller, who's out of Nashville. He's also great as well, but Christian Morris is coming. And if you guys want, if you go to our Connectionology Facebook or YouTube channel, or if you go to our Instagram, you can actually see some of the videos they've been creating for this. We're going to have a women's bonus program. We're going to have a young lawyers bonus program, as well as a special program where we're bringing in all of our staff, paralegals, and office staff and their assistants, and they're going to be doing a special program as well. So if anybody is watching and they'd like to attend, this seminar is going to be just as good for the attorneys as well as it will be for the paralegals who are coming too. And it's going to be all about depositions. So Miss Joy, I hope we're going to see you there.
Thank you.
And
And if anyone gets COVID and you need a speaker, I'll fill in.
you've got it. And I know we've got Marjorie. Marjorie's coming. Ted's coming.
Be there. I'm looking forward to it.
Yep.
Somebody's talked about a
we can-
burger place in the old train station. So noted.
Awesome.
Thank you.
And the date of that seminar, by the way, is November 6th through the 9th. We've got a lot of special events that we're doing every single day. The program is only from about 8 to 2, but you're going to have a general session in the morning, and you're going to do deep dive sessions with small groups because we're only taking like 60 people. This is a smaller seminar, so you're going to get this one-on-one time with all of our speakers. And honestly, those are my favorite kind of programs. And Ted is here. I don't want to keep him too long and everyone waiting. But if you go to connectionology.com, you can look at the agenda. You can check everything out. We hope you guys will come. We've got a few spots that are still available. And then a few rooms left over at the hotel as well. But Ted is here because we cannot end any webinar here at Connectionology without a special coffee giveaway from HMR. And Ted has been giving away thousands of bags of coffees for the last 4 years. So Ted, we're glad to have you with us today.
Apparently I've got a visitor over here too, so.
Oh.
Well,
She's
we
my
love
HMR cat. She's all black and white. So I am excited to announce the winner of our coffee today is Charlene Stovall out of Birmingham, Alabama. So congratulations on some fantastic coffee.
Congratulations. Sure. Wow, we haven't had a Birmingham, we haven't had Alabama winner in a while, so that's awesome. We
Yay.
are
That's
there.
actually where Laura's out of too, and this was not rigged because she was actually the third person on the list. So
I wonder if she actually knows where. That would be actually pretty
yeah,
cool.
that would be pretty neat if they know each other.
And I did have somebody ask me a question about what was Mona Lisa's thoughts and feelings when Charles from Emotion Track was talking. I will find out and I will put that in the email blast that I'm going to send you guys after this webinar. It will have the contact information for Miss Joy, Marjorie, Ted, all of our great partners that you saw today. Thank you for working with them because in return, it supports us here at Connectionology so we can continue doing these webinars for you guys. And I just also wanted to mention that if anyone watching would like to speak on a webinar, please let me know because I think we should continue doing these paralegal laboratories, don't you, Joy?
100%.
Oh, I think it was great.
100%.
And we hope you come back soon.
Thank you.
All right, guys, keep an eye out for your email. Thank you again so much, Ted, for the special coffee giveaway. And congratulations to Charlene. We will see you guys back again on Thursday for our next webinar. If you go to connectionology.com, you can sign up for that because we have Dustin Herman back. And as Miss Dr. Nancy Epstein, she likes to call him Dustin Hoffman.
That's what I was thinking too.
So, but we love those two. They're back with us and you're going to be learning all about spine surgery. So it's going to be interesting.
Yes. Thank you.
Thank you guys. We'll see you back here soon. Appreciate your
Bye.
Thanks.
Thank you, everyone.
Bye, everybody.
Bye.